Okay, next up is a conversation about technologies and privacy issues in a law enforcement agency atmosphere. Now, we're not going to talk about the typical use of social media and technologies and handheld devices and things like that you normally would talk about in a criminal justice class. A criminal justice class, you would address how effective these tools are, how they are very valuable crime fighting techniques, and Facebook pages and websites of agencies help in building trust and transparency to the community it serves. There's no doubt that technology advancements in the area of the computers and internet and social media has really been a powerful crime fighting tool. You can put up lists of the most wanted, and crime stoppers can get leads submitted to them anonymously through various social media sites. But that's not what we're going to talk about. Our focus here is on controlling the risk of the use of social media and these technologies by a law enforcement agency. Because as a legal advisor to law enforcement agencies like myself, I'm always paranoid. I'm always, if you will, very cautious and worried about liabilities. And liabilities do occur in this area, as we'll explore. Now, to help to make this lecture a little bit more interesting, we're going to have some fun trivia along the way. And so hopefully that will keep you interested in the lecture itself. First up is some of that fun trivia. And on the screen here, I have some questions, and let's just test your knowledge. How many constitutions has the United States had up to today's date? Does anybody know? Do you know? Most people would say one, but in reality, we are on our second constitution. Our first constitution was the Articles of Confederation, which didn't work out very well. And actually, the Constitutional Convention was called to amend the Articles of Confederation, but they were not salvageable. So our new Constitution was negotiated at that convention. So we're actually on our second U.S. Constitution. Do you know how many amendments we have? To change the Constitution, you must pass amendments. And if you guessed 20, you're wrong. If you guessed 30, you're wrong. But if you guessed 27, you are correct. Amendments are very hard to pass. And you and I will probably not see an amendment in our lifetime because they take various majorities and supermajorities, not only on a federal level, but each individual state has to pass them through a voter referendum. So very difficult. Now, the amendments which are most relevant to our discussion today, what do you think? If you guessed the First Amendment, freedom of speech, and the Fourth Amendment, freedom from unreasonable searches and seizures, you are correct. Those are the two that are most relevant in our discussion today. Now, when we talk about social media, we mean more than just emails. There are all types of communication platforms out there. And here are some of the more popular ones. And they're growing. Some fade away and are replaced by other technologies. But social media is constantly improving. You and I have a digital silhouette somewhere on the internet. What you do on the internet generally can be traceable, and there are a lot of marketing firms that pick up the data and actually produce a digital silhouette for sales purposes on all of us. But social media goes beyond text messages or emails. It deals with all of these social media outlets. Now, first and foremost, just like any other way of controlling liability, an agency should have a good social media policy or standard operating procedure so that its employees are informed and know what they can and cannot do. It's always good to be upfront with your workforce, and you avoid a lot of issues later. And you have to train them in social media programs. I do yearly trainings at our large agency, which has about 6,000 workers, I would say. And I do classes. I have 3 lined up for this year on social media alone. It's not only good to have a policy, but also to distribute it and train your workforce on policies. So social media policies should broadly define exactly what is social media. And here's an example here. There are a variety of online sources that allow people to communicate, share information, photos, videos, audio, or exchange text and other multimedia files with others via online or cellular network platform. This includes, but is not limited to, social networking sites, microblogging sites, personal blogs, personal websites, and news sites. So policies, when you craft them, should be very expansive to cover all kinds of activities, or at least platforms and venues and apparatuses. Your social media should have some general do's and do nots. Here are some on the screen here to help control liability. When displaying personal profiles, do not discredit yourself or the agency. One big no-no is that agencies should really not condone their individual workers wearing a uniform or using the badge or insignia of an agency online. Because right away that sends up red flags. There's going to be a connection, a nexus or a connection between that blog post by a employee and the agency, which you don't want, even if they're on their own time. Employees should be prohibited from disseminating content that is inconsistent with their duties, conduct, and responsibilities of a sworn law enforcement officer or agency employee. And agencies should always control the outlets that are sanctioned by the police department, our sheriff's department, our law enforcement department. It should have a certain department that runs these by professionals. I know in our agency, the Sheriff's Department in Broward County, we have the Department of Community Services, which is really the controller, the gatekeeper of the social media sites. Our Sheriff's Department has a very active Facebook site, has a very active website that is very interactive with visitors. But that's all controlled through a department, through trained individuals. A typical SOP, standard operating procedure, should cover some of these items as well. You cannot prohibit employees from participating in social media or networking while off duty, but they shall conduct themselves with professionalism in such a manner that will not reflect negatively upon this agency or its mission. Employees should be aware that the content of social networking sites may be subpoenaed and used to undermine or impeach an employee's testimony in civil or criminal trial or other official proceeding. So one thing that law enforcement agency personnel should be aware of is that anything you do online generally can be discoverable. And if not easily discoverable by just logging on into Facebook or other social media outlets. And I know that criminal defense attorneys constantly do word searches on arresting officers to find impeaching criteria, and it is relevant to their testimony on the stand as to truth and veracity. So one big thing that all law enforcement agencies should be aware of is that these statements, if made, once they're out there on the internet, they're out there forever. Even if you try to get them down, there's always archival systems and old postings that last. And they can be used later to come back to haunt an agency personnel on the stand. It can be very embarrassing for the agency and the individual. Failure to comply with the above guidelines will result in discipline up to and including termination. That's a standard stock phrase used by many agencies in their policies and procedures to put everybody on notice. So, the right to privacy. You hear that a lot. Where is that in the Constitution? Is it in the amendments or in the articles? Remember, a Constitution starts out with 7 articles and then 27 amendments. The articles actually tell us how to build our government, creates the 3 branches of government, separation of powers, the checks and balances, and then the amendments generally protect us from our own government. A lot of people believe the right to privacy is in the Constitution, but actually it is not. It is read within the Constitution. It's interpreted. The First Amendment, the Fourth Amendment, the Fifth Amendment, the 14th Amendment. These are all amendments in which the U.S. Supreme Court has primarily read and has articulated that the right to privacy exists. Even though it was never spelled out in the Constitution, our U.S. Supreme Court has articulated that this right exists. Remember, we're in a common law country, so we allow our courts to make law, and that is exactly what they did. Now, social media, just talking about social media's do's and don'ts, is really only half the picture, because you also have to address social media access devices. What I mean by that are computers, handheld devices. Those also should be regulated by a law enforcement agency to limit liability. Beyond the use of these are distracting, just think of it. The typical officer in a squad car has a cell phone, has text messages, has a laptop computer generally, issued to them by the agency, has a radio, either in the car or on their shoulder or waistband, or both. They have radar detection systems beeping. There's a lot of distractions, but I'm talking more than just that type of liability, because if they're distracted and get into an accident, that's negligence. We talked about negligence already. But I'm talking about regulating social media devices. And the rule of thumb here, not only in law enforcement agencies, but in all government agencies and government employers and private employers, is the standard of reasonable expectation of privacy. That is articulated by the U.S. Supreme Court and other courts as well. It is the gold standard, the measuring stick, upon which every court will analyze, did the employer's policy or procedure violate privacy in the workplace? Private employers and public employers can regulate their workforce, can monitor them and the usage of social media devices and social media itself. However, if the employee has a reasonable expectation of privacy, that's when there could be claims of violation of privacy. So, this is simple. It sounds complicated, but in reality, the way to get rid of a reasonable expectation of privacy is to dispel it. Agencies do that all the time. Think of your own agency or your own employer. Quickly, they dispel any reasonable expectation of privacy by simply telling you up front that they're going to monitor, they're going to regulate you, they're going to spy on you, if you will. They don't use that phrase, but that's how you effectively dispel any reasonable expectation of privacy, by just coming up forward, telling the employee up front, we are going to regulate you. We are going to monitor your usage of computers, of emails, of handheld devices, text messaging, video and audio recording. And you can do that by computer logon screens when you log in every morning on your computer, or and again, these computer logon screens tend to be very effective because the only way to bypass them and to get into the system every morning is to click I agree or yes. I know that our agency uses them a lot. In fact, I help formulate some of the language. And so it's very important that you have these logon systems so that every day the employee is reminded that there are policies and procedures that allow the government, i.e. the employer, to regulate and monitor their usage of computer systems, handheld devices, and the use of social media, etc., emails. You can also put that, and you should put that in your standard operating procedures and in your pamphlets, posters, circulated in training. Remind employees periodically that they will be monitored. This all dispels any reasonable expectation of privacy. Putting up cameras all around visually dispels any reasonable expectation of privacy. So just don't hide it. Just tell up front your workforce you do this, and you dispel any expectation of privacy, and you can do it. Now, there was a famous case in 2010, City of Ontario versus Quinn, and it actually dealt with law enforcement. It was a city employee, a city patrolman, and they were issued devices to send text messages, and these devices were all paid by the city, the municipality. And evidently, and this is an older case, but evidently the texts were being charged per text, or you got a certain amount, and then if you went over that amount, you had to pay extra. And lo and behold, this particular road officer, who was married, had excessive texts. And so the employer approached the text messaging company and got a hold of all the texts. And lo and behold, this married officer sent about 399 texts that were non-work related, and many went to his girlfriend. Yes, girlfriend. You heard that right. The expenditures on this account were too high. That's what prompted the investigation. An internal affairs investigation was opened, and eventually he was sanctioned. But the case went up to the U.S. Supreme Court because the union, the officer, the officer's girlfriend, the officer's wife, they all appealed. And they said, wait a minute, this is a violation of privacy. And it was an unreasonable search and seizure under the Fourth Amendment to look into these texts. But the Supreme Court ruled that no, this was a handheld device issued and paid for by the municipality, supposed to be used for business purposes, i.e. the agency purposes. And these texts were on the clock when the employee should be working. And the agency dispelled any reasonable expectation of privacy with various policy warnings and standard operating procedures, which the employee should have known about. And the city had a legitimate purpose in investigating the messages. So the Supreme Court came up with a very, very decisive decision against the officer, against the union, and allowing the employer to regulate and monitor these types of devices. Other policy are internal policies that should exist in this area to help limit liability. Is to avoid accidents, encourage or if not mandate hands-free devices when using these while in a vehicle. Text messaging while driving. Actually, It is an infraction in some states and a misdemeanor in others. Violations of local codes and ordinances in some states. Well, your agency should develop a policy to prevent text messaging as well while driving. Again, this all adds up to liability if there's an accident and the officer is distracted. And all of this is very, very discoverable in the ultimate civil lawsuit. Through discovery, these text messages and times of usage will become apparent because subpoenas on the service providers are allowable by the courts. It's all relevant. Here is some more languages that usually a policy should contain. Pictures while at work, especially at crime scenes or fire rescue scenes, may be a violation of the law, and so you should prohibit employees from taking them unless it's part of their investigative process and the pictures are not sent outside of the agency or circulated within the agency to parties that don't need to see it. In fact, in Florida, we have a statute that says a picture of a dead body is not public record. It is public record, but it's not revealable. It's confidential. It can be censored. Can't be published. So you should have these policies in place because every handheld device now is a camera or a video taking device. One big area of social media liability is defamation, whether it's in law enforcement agencies or in the private workforce. Now, we talked previously about defamation. It's an intentional tort. It could carry punitive damages, excessive damages, to punish an employer or employee. There are two types of defamation, if you recall. Libel and slander. Libel is written, slander is spoken. Either one could occur over the internet or by handheld devices. If you think about it, an email is going to be libel, whereas voice chat would be slander. Remember the elements of defamation. There are actually three. Number one, an untruth is communicated. That means a lie. Number two, to a third party. And finally, number three, damages occur to someone's reputation, lost work, alienation of affections, maybe losing a job, loss of reputation, etc. Those are the three elements to a successful defamation claim that a plaintiff must prove by preponderance of the evidence. So an agency can be exposed to liability if their employees are conducting libel or slander over the agency's servers, network, through agency-sponsored handheld devices. Notice, defamation per se does not require proof of damages. So there are certain things that if you say over the internet or you publish in emails that are automatically damageable, meaning the plaintiff doesn't have to prove damages, it's presumed. Usually these are are false allegations of sexual promiscuity, are criminal actions. They're so bad, beyond the decency of society and moral standards, that automatically damages are presumed. The plaintiff doesn't have to prove damages. The court will award money and presume damages exist. Obviously, damages in defamation cases tend to be very extensive. Just because the internet alone, one entry can be viewed by millions and millions of people, could go viral. So you can imagine that tweeting and retweeting of items can cause and expose an agency to lots of liability. So you have to regulate your workforce as a law enforcement supervisor. Have strong policies in place and enforce those policies and do regular monitoring of communications so as not to jeopardize your organization to expensive, costly lawsuits. Now, social media sites, Facebook, Twitter, text messages, those can be considered public record. So if an employee is conducting agency business on any device at any time, the key here is agency business, then becomes public record. And some states allow for vast disclosures, such as Florida. We have one of the most liberal public records statutes out there. We're called the Sunshine State for many reasons. Not just the sun, but also disclosure of public records. But one of the exemptions to public records, one of the exceptions to public records, is that personal information of current and former law enforcement agencies, judges, prosecutors, firefighters, human resource managers, and code enforcement officers and their families is redacted from public records when they're released to the public. But if you use social media and you have a Facebook page and you put this information out there, you generally have defeated the purposes of this particular statute in Florida, because it's meant to protect the identities of public safety workers in general and criminal justice professionals, so that there's no retaliation against them and their families by criminals. But if you're going to go ahead and announce to the world where you live and your phone number and where you work and the address, and when you go on vacation, you've really defeated the purpose of some of these protective statutes out there. So just be aware there is a practical issue and caution of law enforcement employees using social media. A typical policy also have phrases restricting that social media off-duty in unofficial capacity employees are prohibited from speaking or writing in official capacity, or from representing the agency or acting on behalf of the agency. Again, only have one voice, have one department represent the agency's official social media or internet presence. This curtails a lot of problems out there. Avoid talking about your job. Don't use the logo, badge, or online uniform. Be in uniform. This all limits liability to the agency and to the officer themselves. A lot of people say, well, I have a disclaimer on the website. That necessarily does not always hold up. Keep in mind, communication electronically often can be misconstrued and misunderstood. Now, really focusing in on the legal standards of freedom of speech versus social media regulation in the workplace. The cases are evolving, as you might imagine. With technology, the law evolves. And we are in that evolutionary period. There's a lot of gray area. But generally, courts have come out and said, speech which is ordinarily within the scope of official duties is not protected by the First Amendment. The First Amendment may protect speech made by employees in his or her capacity as a private citizen, that is, of public concern. However, in all cases, the employer may restrict such speech if it disrupts or undermines the work atmosphere or agency mission. So even off the clock, an employee can be regulated, sanctioned, or even fired for their conduct. Recently, in March 2015, after 4 months or 5 months worth of an investigation, an internal affairs investigation by the Fort Lauderdale Police Department in Florida, of 4 officers stemming from a 2 or 3 minute video clip, which one of the officers, at least one, if not more, produced, recorded. Very racist. It had references to the KKK, using vulgar phrases, disrespecting President Obama, picturing minorities, African Americans, being tracked down by dogs, loaded shotguns, it appeared, in the faces of minority members of the public. Gruesome, horrible, horrible. And this was all produced, recorded, created, and circulated on private cell phones, on private time, by the officers. All 4 were fired. Why? Because obviously the trust in these officers was diminished in the public's eye. And it hurts the department. So regardless of if it's on someone's own personal time, that's really not much of a factor when it comes to law enforcement and social media misuse. There are some cases out there in 2013, Shepard case, U.S. District Court, children's service worker, a protective service investigator for children, made Facebook postings on her own time, negative comments about the people on public assistance. She made claims that her clients on public assistance buy luxury items, commented that people on public assistance should not have more kids. And I'm just summarizing in real nice terms, in generalities of what the statements were. But as you might imagine, they were very direct and very offensive. The employer was terminated for unbecoming conduct, and the employee sued, claimed First Amendment protection. She was off duty. It was her opinion. Should be free speech. Many law enforcement agencies have these divisions. I know we do. The Child Protective Investigative Services is a very large division of our agency. And this is exactly the type of division that was involved here where she worked. The holding, the state's administrative interest outweighs the First Amendment free speech rights. Negative comments would impair the worker's ability to do her job. Her off-colored comments showed that she was prejudiced against a lot of the clients, the customers, if you will, of her agency's services. The negative comments were potential adverse impact in testimony of the social worker at trial. They could be used as impeachment evidence. So the termination was affirmed. So again, off-duty conduct. Regulations can kick in and sanctions can occur. Another case study. City of Greenville, Fifth Amendment, Appeals Court, 2015. Police officer on her own time posts on mayor's Facebook. She's critical of the police chief's decision on failing to pay gas for police going to a fellow officer's funeral. Multiple posts continuing to challenge the police chief's lack of leadership skills. So this officer is complaining about the police chief in a very public way. The police officer, as you might imagine, was terminated, and she sued the agency. Again, the holding. First Amendment right to free speech was not absolute. Keep in mind, all of our rights in the Constitution are not absolute. They can be reasonably regulated. A lot of people get that confused. We have the Due Process Clause in the Constitution in 2 places, the 5th and 14th Amendment. Identical language. Life, liberty, and property will not be deprived without due process of law. It means that our government can kill you, but they must give due process before a full trial, appeals, etc. And if you're convicted and sent to death under the death penalty, you've been given due process, assuming you've lost all of your appeals and have not been your sentence has not been commuted by the local governor of the state or the president, etc. So anyway, the holding here is the First Amendment right to free speech was not absolute. The police officer's interest in speaking did not outweigh the department's interest in promoting efficiency. So it was very disruptive what she was doing. The police department's function as paramilitary organizations charged with maintaining public safety and order, they are given more latitude in their decisions regarding discipline and personal regulations than the ordinary government employer. So keep that in mind. Law enforcement agencies have a slight different standard because of their paramilitary organizational structure. Discipline is of paramount importance, and so it must be guarded and protected. So her posted comments did not address a matter of public concern, but instead involved a dispute over intra-departmental decisions. So the discharge of the officer was proper. But see, when you hear that phrase, but see, it's actually a legal citation format in which a following case disagrees. This is actually an administrative ruling from the National Labor Relations Board, the NLRB. That's an administrative agency on a federal level that hears complaints between unions and management. And it issued an administrative ruling that the employer violated the NLRA when it terminated 2 employees for participating in Facebook discussions criticizing the employer's failure to withhold the proper amount of state income tax from their paychecks. Now, this particular decision did not involve law enforcement, but it is applicable to all employers. The employer did not contest that the employees engaged in protected concerted activity. Concerted activity is a legal phrase that describes union and labor organizational efforts and communications, intercommunications between the members, by discussing its tax withholding calculations on Facebook, but argued that the employees' conduct, including using profane language to criticize one of the owners, was so disloyal that they forfeited the NLRA's protection. At least that's the employer's position. The board disagreed that the employees' comments were maliciously untrue and concluded that the communications were protected because the purpose of the conversation was to seek and provide mutual support, looking toward group action to encourage the employer to address problems in terms of the employment, not to disparage its product or services or undermine its reputation. So here is a victory for the employee, the terminated employees. So keep in mind, these cases go both ways. And it's a developing area of law. Until a U.S. Supreme Court case comes out directly on these issues, we have different jurisdictions somewhat doing different things. But generally, a law enforcement employer can regulate and do regulate successfully off-duty conduct using social media and on-duty conduct, obviously. The key here is to dispel any reasonable expectation of privacy. Is a Facebook like or dislike a form of First Amendment free speech when it's done online? Interesting question, and there's a direct case on point. The Fourth Circuit Court of Appeals, 2013. In that case, a sheriff was up for election, and the opponent had a Facebook page. And the opponent running for sheriff had some current employees who liked him, so these current employees visited his Facebook and liked him. They gave him the thumbs up symbol used on Facebook. Well, the sitting sheriff, after he won an election, the allegation was he retaliated against these employees for supporting his challenger, and they were terminated. The employees took the position that they were terminated because of their communications, the thumbs up or thumbs down, if you will. Here, the thumbs up for their competitor's Facebook page. And the whole issue was, is that a form of free speech, communication? And the courts, as you might imagine, said yes. It wasn't so clear. The trial court said no, but the appeals court said yes and overturned the trial court. Again, a victory for the employee. Here is some more common sense
Social media tips. Don't post anything that you wouldn't feel comfortable posting or discussing in the lunchroom. Don't share work-related information that is not approved for public release. Remember, a picture is worth 1,000 words. It gets on the internet. It could have 1,000 negative words. Everything you post, tweet, like, etc. can all be used later as impeachment. We talked about that. Of your character when you testify on the stand in court. E-communications and text communications can, by their very nature, be misleading or received in a wrong light by the reader. This miscommunication can cause problems that could have been easily cleared up quickly in follow-up phone conversation or correction. Avoid the urge to participate in electronic water cooler conversations. That's kind of the phrase or the descriptive phrase being used out there. Again, these are all common sense tips that the legal advisors should be articulating through training of their workforce to avoid liability issues. Managers should avoid friending fellow employees you supervise. No mandatory friending of fellow employees. In other words, you can't force fellow employees to be your friend on Facebook and allow access to their Facebook page. Do not demand passwords of employee social media sites from them. Employers at one time were demanding access to various social media sites and passwords from their applicants and current employees, and that was against the law. And in some states, specific statutes like California have passed statutes preventing this. Law enforcement agencies, by being governmental entities, cannot do this unless they have a court order, because it's a form of Fourth Amendment unreasonable searches and seizures, assuming there is no exigent circumstances. These are some more good tips to avoid liability, to avoid 1983 actions against the agency. Do not forcibly seize personal handheld devices from employees. You do need a warrant unless exigent circumstances exist. Do not shut down an employee's social media account. Do not use employees' log in, log on credentials. These are all issues, legal issues that can be problematic to an agency down the road. Some more constitutional trivia. The drafters of the Constitution mentioned intellectual property rights, IP rights, as we say, copyrights, patents, and trademarks in the U.S. Constitution. True or false? This right was actually embedded in the Constitution. True or false? If you said false, you're wrong. Actually, Article 1, Section 8 of the U.S. Constitution preserves to inventors patents and copyrights. Our founding fathers, if you think about it, were very smart individuals. They had a lot of creative writing and works of art and inventions, and they wanted to protect them. So they actually put a clause in the Constitution, very early on in the Constitution, Article 1, to protect their own financial interests and to promote these types of ingenuity in the new society they were creating in America. Another area of legal liability in social media use is copyrights, copyright violations. Just because something made it on the internet does not mean it's a free-for-all. It can be used by everybody. It does not mean it lost its copyright protection. Keep in mind, under U.S. law, we follow common law copyright. What that means is when somebody takes a picture or creates a poem or a song or creates PowerPoint or writes an article, automatically, they don't have to file anything, automatically it becomes copyright of theirs. Now, from a legal perspective, it's probably a good idea to file and register it at the U.S. Copyright Office, www.uscopyright.gov, but you don't have to. Under common law copyright, it automatically is copyrighted. And just because it makes it on the internet, a song or a picture, does not mean that you can copy it without the author's permission, especially not for commercial use. So, a lot of law enforcement agencies get themselves in trouble I see this all the time, and I've been involved in cases where training materials or advertisement materials were lifted off the internet. Our portions, our pictures, our phrases, our concepts were lifted off the internet. And if they're copyrightable, if they fall under copyright, that's a problem. Same thing with trademarks and service marks. Violations of intellectual property rights, IP rights, result in injunctions. That means that agencies can be very embarrassed and get hit with an injunction, a cease and desist order by the courts if a plaintiff asks for it and is entitled to it. Agency liability under federal law, because copyrights, patents, and trademarks are federal in nature, federal law. And if you are aware of U.S. Constitution, you know that if federal law and state law conflict, you know that federal law prevails. The reason why I mention that is often state sovereign immunity statutes, which we talked about before, that limit liability, can be pierced because the federal law trumps the state law. Now, there is a thing called fair use. Fair use applies only to copyrights, not to trademarks or service marks or intellectual property rights or trade secrets. Fair use is a defense that applies only to copyrights, and it allows for limited non-commercial use of works that are copyrighted without the owner's permission. If it falls under certain limited uses, such as, again, non-commercial in nature, usually educational in nature, or use in court opinions, or news media, or satire, limited reproduction for academic work. These are all fall under fair use defense. How much is too much? Well, it's on a case-by-case basis, but generally you can use some of it, but you can't use all of it, if that makes sense. Fair use defense. Keep that in mind. It allows for limited use of copyrighted materials and under certain circumstances. Should always seek legal advice from your legal administrators or legal advisors within the agency on any publications being created. Make sure that they are original. Have your force go out and take pictures themselves. That's called a works for hire. That someone on the clock is given a job to create something for the agency or for the employer. It's a works for hire. Therefore, the employer owns it. So getting back to state sovereign immunity levels, if you recall in an earlier lecture, we talked about how certain states, many states, have sovereign immunity rights. Remember what sovereign immunity, just to refresh your recollection, means. A long, long time ago, when the King and Queen of England were in charge, you could never sue the king or queen. They were always right. They were immune by their nature of being a sovereign leader, the king and queen, monarch. They can never be sued. They were always right. They can never do wrong. Well, we as a common law country actually continued and carried forward that principle, but we lost the king and queen, but we also transpose that protection to government agencies, but in a limited sense. Not so much that they were perfect, because remember, back in the day, the king and queen were perfect. They were direct descendants from God. They could never do something wrong. Therefore, they could never be sued. But our government does a lot of things wrong. Can always be sued. And if it doesn't get sovereign immunity, it would probably go bankrupt within a year. Federal, state, and local governments. Law enforcement agencies would be bankrupt within a year because they're constantly being sued. So in the United States, we still adopt this principle of sovereign immunity, but we limit it, meaning you can only sue for so much money. In Florida, we have Florida Statute 768.28. It allows for negligence lawsuits against government agencies in Florida, i.e. law enforcement agencies. But it limits recovery. up to 200,000, or in some cases 300,000. So this way, our agencies don't go broke. Sovereign immunity automatically kicks in if you're a government agency in Florida. So I know as a legal advisor to the Sheriff's Department of Broward County, we're very happy about this statute. However, it can be pierced by federal violations. Remember, federal law trumps state law, and sovereign immunity statutes are on a state level. A 1983 action, as we talked about, pierces sovereign immunity limits, and agencies can pay millions of dollars. Intellectual property right violations. Agencies can be sued under federal law, and that federal law pierces sovereign immunity limits. So it's a very, very necessary discussion that we're having about intellectual property right violations. We do not want our agency personnel to be copying things without permission. You can get permission often by just approaching the author and getting them to sign a license agreement or permission to use their work. We just answered this piece of trivia for you. If federal law copyright violations and court order remedies against the violator are in direct conflict of state laws, i.e. doctrine of sovereign immunity, which one prevails? We know that the federal law trumps. And so sovereign immunity limits are pierced under the supremacy clause of the U.S. Constitution. Touching on a topic that we kind of touched on before, but if an employee is conducting agency or law enforcement activities or agency business online, even off duty, but they're still conducting agency business, it becomes public record. Again, under Florida law, we have a very, very liberal statute that defines public records in a very, very broad sense. Florida Statute 119.011, 011. And it's very detailed, and it basically opens up the books of all agencies. However, it does offer a lot of exemptions, protected. So even though everything is public record, it may not be released. It can be redacted in some circumstances. So keep that in mind. A lot of people get confused between public record and exemptions. Everything is public record that an agency creates, but it may be subject to exemptions from release. So if an employee is using social media to conduct agency work, whether it's text messages or handheld devices, their own servers, it can become public records. So obviously you want to discourage that. You do not want employees to conduct agency business over non-agency owned assets, i.e. computer systems, servers. Warn the employees. If you tell them up front, listen, your personal email addresses and your personal texts could be public record if you conduct business over them. That usually stops the employees. Puts the fear of God in them because they realize, oh my, I don't want people to read my stuff. So they don't conduct agency business over their personal email addresses and personal text message handheld devices. So that's always important to inform your workforce of the laws through training. And that's what I do in my training with my agency. Again, employee privacy, you get very little privacy in the workplace, at least in the United States, so long as the employer has dispelled all reasonable expectation of privacy. You've heard that phrase time and time again because that is a legal standard required by the courts before invasions of privacy are okay, if you will, if the employer dispels any reasonable expectation of privacy. Some of the trending things here: GPS tracking on police vehicles. This is common. It's not a violation of privacy, especially if you tell the employee up front, hey, listen, all of your units are GPS tracked. And that generally is the case now. Same thing with laptops. Same thing with black box automotive data, automobile data. All newer versions in almost every make and model have a black box inside them that records data, speeds, braking, applications of brakes. And that all can be used by an agency without the consent of the employee, so long as the black box, if you will, is government owned. In other words, the unit or the vehicle is a agency's vehicle. Now, in a criminal investigation, it's advisable that you get a warrant unless there's an emergency or exigent circumstances, even though it's government assets, whether it's a cell phone, text messaging, radio, a desk, a computer system, a server, a GPS tracking device, a black box automobile data box. Generally, if it deals with criminal sanctions, you should get a warrant. That way, there's no arguments that the Fourth Amendment has been violated, because you as a government employer, the law enforcement agency, is the police. And you don't want an argument that you violated the Fourth Amendment and that the evidence can be suppressed. So keep that in mind. The general rule of thumb, unless there's an emergency or exigent circumstances, just secure the units, secure the area, secure the desks, secure the computer server, and then go get a warrant. Okay, I hope that you've enjoyed the presentation here on social media and handheld devices and other computer technology. It's a growing area of the law. It's in transition, and law enforcement agencies should be very, very cognizant that this can expose them to tremendous amounts of liability. But it can be managed effectively through good written standard operating procedures and training.